Oh, here's a point. Your time to shine, Al. Have you talked about the ACLU charges? I do see another super chat that I might interrupt you to come to when I find it. I have to scroll up and down to find these things. Okay, yeah, it was just a thanks. So we're talking ACLU now, guys, and their claim for costs. But I'm going to also thank Coco for this super chat at the same time. Take it away, Al. What are your thoughts?
Yeah, well, we were going to chat about this. Okay, first of all, just to explain what the ACLU thing is about, right? When you sue somebody, we go through a thing called disclosure or discovery in the States, where you have to disclose what evidence and documents you have. So everybody has to exchange those. Sometimes, though, you may say, well, actually, there is some evidence that I need, but it's in the control of a third party who isn't a party to the case. And for technical reasons, you know, I don't have a beef with them, so I can't make them a party because I don't have a claim against them. But I want the evidence they have. And you can ask for it and say, could you help me? But they might say, well, no. So you can apply for something called a third-party disclosure order, and that's the same in the US and in the UK, where you go to court and you say, we think this party has some evidence that is essential to this case being tried properly, because in the absence of this evidence, it wouldn't be right. You couldn't make a decision because you've not got the full facts. And you go along and you say, we want this person, this is the evidence we want, and we want you to force them to hand it over. And that's what actually happened in the UK trial, where the Depp's team went for a third-party disclosure order against Amber Heard. And the judge said, well, no, I'm not going to make an order against her. You'll just have to deal with whatever the Sun provides you. In, however, the US case, Johnny Depp's team brought one against the ACLU to say, we think you have some evidence that is pertinent to this case. That would assist us in terms of, and it was all the background to the donations. And of course, then it transpired they had effectively they had libel checked the op-ed. And, you know, there was all that thing that the op-ed had been done sort of in collaboration. So that was a very useful exercise. But the rule is, because the third party doesn't have a dog in the fight and isn't, you know, it stands to gain or lose nothing from this, why should they have to pay for the cost of the disclosure exercise? So the usual rule is, if you are successful in obtaining third-party disclosure, because you're the one who wants the evidence, you pick up the tab for producing that evidence. Now, what the ACLU have done is, there's no dispute. They're saying that you're totally entitled to your photocopying fees and paying some staff to pull things through the archives. The issue now is, should you have to pay for because the ACLU got lawyers to check what was disclosable, and they objected to this disclosure, and they did a very, very sort of detailed analysis of what should go in. And the argument is, should Depp's team, or Depp really, have to pay for all that work? Because that was to benefit the ACLU. They could have just handed it all over. Now, I've read the actual, because I am so nerdy, I read all the applications in this. In fairness, the ACLU make a good point, because Depp's team said, we want you to, if you're claiming any sort of privilege, we want you to line by line do it for every single document. Because they would say, well, you know, this class of documents we say, you know, isn't disclosable because of X. These documents aren't disclosable because of Y. They said, no, we want you to do it for every document, and say why. And they're saying, well, that cost us $86,000 or something. So this is the issue as to whether Depp's team have to pay for all that work. And the ACLU's argument is, and I can understand people say, well, the ACLU are the villain of the piece and they're on Team Amber and therefore they should suffer the consequences. But the law just had, as far as the law is concerned, they're not a party. So should they have to pick up the tab for that? I personally think the judge is going to say, yes, Mr. Depp's team, you must pay the ACLU's cost, but I think she's probably going to knock them down a bit on the actual amount of charges, because they might say, well, actually, some of that work was unnecessary. Some of your billable hours are a bit expensive, although Depp's team actually do concede. Lawyers always concede that other lawyers' rates are really reasonable, because because we don't want to be on the receiving end of that. This is outrageous. How can somebody charge this many dollars per hour? Because of course, then the next day you're back in court going, well, we want to claim our costs and we think these are perfectly reasonable. But that's what all this is about. Now, this brings us to another thing, and hopefully this is something your viewers can use. How do you decide who to sue, whether somebody's a party or somebody's just a potential witness? And disclosure can be a part of that. You can actually do what they call pre-action disclosure. We can go to court and say, I am thinking of suing somebody, but it might be they have a fantastic defense to this. And rather than go through all the expense of a trial, I'd like you to order them to do the disclosure beforehand. Because if it comes back and I think, oh, actually, yeah, I'm on a non-runner, I'll take a view to discontinue the case or to decide who I should properly sue. So that's actually called pre-action disclosure. There's an interesting case at the moment where somebody applied for pre-action disclosure, but after they'd issued the claim, and they go, well, you jumped because two departments weren't talking to each other effectively. So somebody said, oh, we need to sue these. And the other people go, well, we need to find out whether we should sue them. And the court has said, perhaps not unreasonably, you can't apply for pre-action disclosure post-action. But this all comes into it. And at some stage, maybe we should chat about what do you do, and this is for your viewers, because Depp had to decide, did he sue the Sun? Did he sue Amber Heard? Did he sue the ACLU? What if you pay for somebody to install a new boiler and it doesn't work? And the builder says, well, I installed it properly. It's the boiler's not right. But the boiler people say, no, the boiler's fine. He just did a bad job. And you just don't know. You're not an expert. Who do you
common complaint? It really is. I mean, and sometimes I'm sorry, I'm just looking for a super chat at the same time. But I will find it eventually. But it's a common complaint that something's been purchased and installed. There's two people. I found it. I think it's this one. So I'm going to put it on screen so I don't lose it again. So forgive me for the delay for getting to you. But it's a common complaint when someone has either bought something, it's been purchased, it's been installed, and who's to blame? Is it that the thing doesn't work, or has it been installed badly, or has it not been maintained? Is it damaged by the person that runs it? Did they not run it properly? Who is the correct defendant is the appropriate question. And the way the law looks at this is very bluntly, well, sue them both if you don't know who it is, and the court case will decide who's responsible. It's just that if you lose completely, you're responsible for both parties' costs because you've wasted everybody's time and costs. And so ultimately, if you're definitely right and it's one person's fault, then the other person's been brought in because it was their fault, then they'll have to pay their costs. And so
it's a big thing as to whether, because by definition you can only succeed against one person, so the winning defendant is entitled to their costs, but it's whether you pay their costs or the losing defendant pays their costs. And that's a practical issue that crops up quite a lot. Another thing is, if you are being sued yourself, say you're a builder, you put a kitchen in and somebody sues you for negligent work, and you're saying, well, actually it's all hypothetical. Travis Perkins, not suggesting Travis Perkins would be at fault, but it's Travis Perkins applied the wrong thing.
You must be a defamation lawyer.
I know. It's like, yes, I'm using them as an example. Travis Perkins is actually a very, very fine thing, and they're an excellent source of free coffee, I have to say. But yeah, if you are being sued by somebody and you say it's not my fault, you're suing the wrong person, you can go back and say you should sue that person. But if they say no, I'm suing you, you can join the other person as a defendant.
You can join, absolutely. You can join them and have lay the blame at someone else's door.
Yeah, you just go to court and say, I want you to add this party as the defendant because I'm saying it's their fault. And that happens. And that happens. So
yeah, I had a very interesting case. There was fraud involved, and fraud is one of these where it cuts through what we call the corporate veil. So you have a company limited by shares, limited liability for the purposes that the individuals behind the company can't be personally bankrupted by the actions of the company. Therefore, it's a limited liability. However, fraud will cut through that because the law says you can't set up a company for fraudulent activity and then protect the people behind doing the fraud. That just doesn't make sense. So you can cut through. So we had an interesting case, and I will come to the super chat question in just a minute. Right. Well, I'm sure Al's got an answer lined up, but it was an interesting case where we were suing the company, and the people responding said, this company has got no knowledge of this customer. I mean, like, nonsense. We've got documentation from you. It's clearly from you. And they said, and one of the directors said, no, it's this guy, pointing at one of the previous directors. So we said, well, do you know what? Because of what you've said, we don't know who it is. We applied to the court to apply it to add everybody to the claim. everyone can come to the party. Long story short, we got the judgment against everybody, the company, the directors, everything, because the whole thing was a bit of a sham. So said the judge. And so we got this huge judgment against them all. So do you know the etymology, Al? Cuddling badgers, is that
it was a reference to